or says that they smell cannabis. And that's the other big concern here, is that there are cases that we have recognized here. There's been, reporting on it in other states, and I included the report from the San Francisco Times in my testimony. Oftentimes the odor of cannabis is alleged, and that is never proven. An officer is found not to be credible by the court. There's no cannabis ever recovered. And at the end of the day, once you say you can smell cannabis, that's a blank check to get into the car without any way to verify if that was ever true or not. For better or worse, body camera has, I think, exposed a lot of things, and a lot of things our clients have been telling us for a long time about their experiences with police in ways that I don't know, we have a lot of technology now that we did not even have 5 years ago. So maybe we will be able to get to that point. But where we are today is there's no way to verify that that odor is there. So even taking separate from the concern that what is this odor even connecting to, and why do we think it is important in an era of legalized cannabis, there is really no way to verify if it is true or false.
No, I appreciate that. Thank you. I wanted to just get that on the record, the distinction between the swerving plus cannabis smell device. Just, someone's got a tail light out, you pull them over, then you're like, I smell something.
Yes.
It's an important distinction to make. And then I guess I don't want to belabor this, but it's interesting. So on the bill, it talks about based solely on one or more of the following, and it talks about odor of burnt and unburnt cannabis. And I wanted to just understand the genesis of that, because obviously now you've got edibles, you've got gummies, you've got all sorts of, you've got, oils, you've got a lot of things you can infuse drinks. You've got a lot of stuff you can kind of consume, and just wanted to understand the purpose between the burnt or unburnt.
Sure. Well, I just think that those are the two forms that you can smell it. And so, that's why that's important for us. And I think that's also why it was important to also include, not just limiting it to odor, but also to the actual possession of the amounts that are part of personal use, and also money in proximity to cannabis. Because what we don't want is for people who are engaged in the legal cannabis markets all of a sudden say, and this is a fact pattern that comes up a lot for our clients, you have a personal use amount of another type of drug, a personal use amount of crack, for example, but you have money near it. Now, you could have been buying it because you are a personal user, but all of a sudden that is turned into possession with intent to distribute. And we also see that in the cannabis context less now, but we certainly do still see it as a justification. And actually, Delegate Taylor, that was what she spoke to with the experience of her daughter, is that her daughter had cannabis in various parts of her vehicle, and that was that she uses for personal use, and all of a sudden that was amalgamated together, and they said, well, you have enough that you are distributing. And so, I think that what the three components that we have been outlined in the bill are really to protect your ability to legally engage in the cannabis market, and those are the actions and facts around that are protected.
And then that was the last point. You touched on this, but it said, the element, subpart 3, the presence of cash or currency in the proximity to cannabis without other indicia of an intent to distribute, but it doesn't define how much cannabis. So in theory, could I have 100 pounds of cannabis with me? That's I wondered what the history was there.
So I think that I don't know if you want to speak to that more.
Yeah. So, okay. So what that really is about is, again, cannabis is a cash and carry business, period. And so we know that this is really within the bounds of what's going to be legal. Okay, 1.5 ounces. All right. So that's kind of what we're thinking about here. We're still trying to keep it within the legal bounds, but we're saying, for odor, these are the three things that you cannot be violated for.
I literally circled this because I was like, wow, that's how much, because I know July 1st, we got 1.5 is 2.5 is decriminalized.
Right.
But what
absolutely.
if I had 100 pounds? It doesn't specify.
Yeah. The poundage. Okay.
Yeah.
But also, I think practically, if you have more than 100 pounds, then that's in combination with the currency, right? So that's why we're looking at the totality of the circumstances. We're not just saying, well, you have money in cannabis, so therefore there's nothing. Does that make sense?
Yeah, but under the language, I could have a stack of cash and 500 pounds or 100 pounds of cannabis, and that cannot be used as indicia of an intent to distribute.
Well, I think that once you
am I reading that wrong?
Yeah, that's not the
The presence of cash or currency in the proximity to cannabis without other indicia. What is the other indicia that would be necessary or sufficient for that?
So I think typically you would have like baggies, you would have small scale, like scales and cards and that type of thing. But I think, again, if you have someone that has that large amount of cannabis, that's a different fact that you are adding to the presence of cash or currency in proximity to cannabis. I'll also say another population that we're concerned with and that this happens with right now is people who are medically able to use cannabis, who can possess legally up to 4.5 ounces. I had a case in the past year that started with someone saying there's an odor of cannabis in this parking garage. And the officer comes up to this parking garage, smells cannabis and sees these two Black men. There were other cars that were leaving. They go up. One of them is a veteran with PTSD who has a card, says that they have a card, has an amount that is within the legal amount for his medical card, but still his vehicle is searched and everything that comes from that. And so, those are parts of the concerns we have there. But again, I think that if you have 100 pounds of cannabis plus currency, that is the additional factor that we're looking at. So I hope that makes that clear.
I understand the intent. The language doesn't say that. And so I'm trying to figure out, why not be more prescriptive and say like whatever the amount is for you can possess for medical cannabis, or I'm just trying to figure out the difference. But I get the intent.
Sure.
Yeah. All right. Other additional questions? Senator Carter.
I just wanted to touch on that issue of cash a little bit. In my experience, and there could be some members of the body that don't realize that there are certain members of society that don't have checking accounts, don't have credit cards, may be employed, and when they go to the check cashing place, they get all of their employment cash place, they get all their cash on them. And so can you speak a little bit about how that has been and can be misconstrued to indicate criminal activity just because someone might have cash? And there are many people that don't have the credit cards, don't have the checking accounts, and they keep cash on them. It's what they do.
Sure. So I think, and thank you for that question. I think regularly a fact that we see is that if someone has a lot of ones or a lot of small bills, that all of a sudden that even if they have a small amount of cannabis, less than 10 grams, that is used as being an indicia that they are engaged in some type of drug trafficking. I think for our citizens who live in areas of the state have been designated as high crime or something like that, your possession of multiple bills, a lot of bills and wads of cash is all of a sudden converted into you being engaged in some type of drug trafficking or going to drug traffic. And so again, it doesn't really take into account the realities that there are many, many citizens here who do exist with cash and have a lot of cash on them. And that in and of itself is not a crime.
Mr. Murphy, did you want to speak to that as well?
I think the spirit of the bill is that if you see cash and you smell cannabis, that's not enough. Period. Now, if you see a large amount of cash, is that enough? I don't think so, because that is not necessarily indicia of criminal conduct. So why is it illegal to carry a large amount of cash? So you got to understand that there are people out here in who are not part of the credit economy. There are a large number of people who are part of the cash economy. And so when they have money that they want to take from one place to another, they take it in their car and they pray that nobody steals it, nobody carjacks them. And Lord knows they don't want the police to take it on some kind of pretextual basis that you may have been smoking weed in the car. How does that work? And you can't justify a search based on what you have found in the search. That's a fundamental constitutional principle. And so, yeah, somebody's going to get away with something, but you have to have standards before you can invade the privacy of that person. And so you can't justify on a slim read searching the car because you might find a large amount of marijuana in the car, or because you might find a large amount of cash, or because you see a large amount of cash. It's just not right. And so what we ought to do is take the odor of cannabis out of the equation altogether. And so what you would see if you're a police officer is you'd see the cash on the seat. Does that give you the right to search any car? No. Does it give you the right to invade every space in the car? Absolutely not. And so I think this is a well-intended, pretty clear objective. And what I hear the question being based on is, what if what's behind what the officer sees is a lot of marijuana or a lot of cash? You gotta have probable cause. You can't have a suspicion and go further. And where is the probable cause in the example you're talking about? You see what I mean? So you start there. What is the justification for going inside this person's car? And do we have enough probability to do that? And because it's a car, you require probable cause.
No, I was just looking at the possession with intent to distribute piece and the statute, which reads in relevant part, except as otherwise provided in this title, a person may not possess cannabis in sufficient quantity reasonably to indicate under all circumstances an intent to distribute or dispense cannabis. And then there's obviously a carve out there for civil use amounts or personal use amounts without other evidence of intent to distribute, dispense, do not constitute a violation of this possession with intent to distribute. And so it seems to me now the way that the statute reads is that a large amount of cannabis plus cash would be the indicia sufficient to say, hey, look, this is possession with intent to distribute. That's what I'm relying on, just the statute. But yeah.
So sorry that I didn't say this explicit because I realized my answer got like more into the weeds before getting to the answer that it's still a crime. Yep. It's still a crime to have 100 pounds of weed. So that is, if you see someone with 100 pounds of weed, if it's in plain view, then that's a crime and you can arrest them for that crime. And I think what Mr. Murphy was just speaking to is what this bill is really getting at is the reverse, is you're saying, oh, well, odor plus you have some cash necessarily means that you're intending to distribute, which is not the case. So there's nothing in here that's stopping officers from doing something when they come upon a criminalized amount of cannabis, because that's the crime. Just the same as, even though we have gun licenses, people, if you're seen in possession of a gun, you can be arrested, right? So in public. So that is really, I think, how that tension sorts out.
Let me give you a hypothetical. Let's suppose somebody is carrying 100 pounds of weed in the trunk of their car, and the officer smells the odor of cannabis, and he sees money on the seat. Does the officer, without knowing or having probable cause that cannabis is in the trunk of the car in a large quantity, does he have probable cause to search that car? No. So look, probable cause is the only protection we have, that and the exclusionary rule, against officers being permitted to do arbitrary searches. And if we omit the value of requiring probable cause in our analysis, we're going to get skewed results. So going back to that hypothetical, if all the officer knows is that, and there's 100 pounds of weed in the trunk, if all the officer knows is that he smells weed and that there's, let's say $1,000 on the trunk of the car, on the seat, and he doesn't have any way of knowing that unless he counts it, by the way. So let's be fair about this. Is that enough to search that car? And I hope the answer is that no, it's not, even though a criminal might get away. Because otherwise, we're conflating two things that ought not to be conflated. We have a probable cause standard that's inviolate, and we ought to stick to it.
Just understand, like these, your opponents are going to bring all these points up. So this is the opportunity for you all to address them now. So you got I could belabor on this, but I'm not going to. So I'm sure that's going to come up again. But well, thank you all very much for being here and for your testimony. Oh, Senator Sidner, go ahead.
Thank you. And I hadn't thought of this until you raised the question about transporting, but I'm curious and I'm asking because I'm ignorant on this. Medical marijuana or cannabis, how is that transported? Do any of you know?
What do you mean, as a matter of business practice?
Right, I mean, because it,
There are companies that have the right to transport cannabis under controlled circumstances, under the old statute. You have, secured vans, you have guards, et cetera. So that's how it's done when it's being delivered by the grower
okay,
to the dispensary.
thank you. Thank you.
But if somebody is going to go purchase it, they would go to the dispensary, they'd be in their car
Right.
and they drive home. And we've definitely gotten complaints from folks who have left the medical dispensary, are legally allowed to obtain their medicine, and have been stopped and charged with possession or intent to distribute based solely on the fact that they might smell odor or they believe the person is intending to distribute. That happens all the time.
And that's why I wonder why not say be more precise, just say the legal amount, whatever that is. I mean, something like that. You know what I mean? I wondered, that's why I wanted to know the history of why you just left it open-ended.
So the other thing
Senator
I would just add is that by just simply looking, they can't.
Please? Okay, sorry. Sorry.
By just looking at a quantity, they cannot tell without weighing it how much they have in their car. So I think it's already implied that if they have a large amount, that is already prohibited. And that then again, to what Michelle said earlier, is in their plain view and they could then, follow through. So I hope that makes it more clear. And the other thing I'll just add is that simply smelling the odor is not enough to determine how much weight there is in the car either. Someone could have simply a gram and it could smell like a whole lot and it's not. So that's why we're saying, again, simply odor alone is not enough.
Thank you. I see this bill has been amended in the House. I saw some opposition to the bill. I wondered if there's been, and there's two questions. One, if some of the oppositions have changed because of the amendments of the bill. And Mr. Chairman, I don't know if people can submit testimony to this committee when we have a House bill that is amended. Can they submit new testimony or updated testimony in the system? Yes. Okay, is that in our floor system right now? It should be.
Yeah.
In the House bill, not the Senate bill. Okay, cool. Thank you.
Yes, the opposition has not changed. We have not had anything.
Cool. Thank
Okay.
you. Appreciate it.
This has been great. This has been I learned a lot. So thank you all for this. Additional questions from the committee? All right, seeing none. Thank you very much. No, it's good. This is very good. Thank you all. All right, next is Malcolm Ruff here. I know. Welcome. Rusty Carr. Did I just get trolled or? Yeah. All right. It was bound to happen one day. All right. Welcome. Thank you very much. Welcome.
Thank you all for allowing me to be here. I joined Mr. Murphy. I work at the Murphy firm and we are staunch proponents of everything good?
My apologies. We'll give you more time back. My apologies. We're looking, I missed Mr. Love. Is Davon Love here? Okay. Well, when he gets here, we'll restart you up. My apologies.
We find it our job to protect civil rights on a daily basis. And this is about ensuring that we as you guys as a body are focused on what we really hear about. Creating another level of de-escalation, I think, is something that you guys really need to consider in making sure that we get an exclusionary rule here. We just left Prince George's County and announced settling a matter with the county involving a young man named DeMonte Ward Blake, who we represented for the past 3 years. Unfortunately, Mr. Ward Blake is no longer with us. But I know in my heart, when he was stopped on Wheeler Road in Prince George's County and the smell of cannabis was emanating from his car, that created an escalation in the minds of the officers who ultimately called in backup officers for one skinny black kid who was driving a car that had bad tags on it. And that traffic stop, which should have ended with a ticket, ended with DeMonte being slammed on his face, nose broken, neck broken, and paralyzed for life. This is an opportunity for you all to create a level of de-escalation that right now, our law enforcement officers as a whole do not have not displayed the ability to be able to effectuate. So I'd ask you all to think about that. Not only the idea that, you know, the smell of cannabis shouldn't be enough for a search. Not only we should also take the contraband demarcation away from cannabis, but creating a level of de-escalation that will ensure, based on the numbers that Mr. Murphy already talked about, that Black and brown people and all people are protected from what we know to be escalation on a regular basis by law enforcement officers.
Thank you very much.
Thank you, Chair Smith, members of the committee. My name is Rusty Carr. I'm a resident of Mount Airy. If I'm driving home after a day of golf, had a beer, I got stopped for bad tags, the officer smells the beer on my breath, is he allowed to search my car? I don't think so. What's the point? This bill allows police officers to continue searches of cars based on odor of smell, and they're allowing it only within reach of the driver. But is the smell of cannabis probable cause to determine impairment? It is not. This is cannabis, it's hemp, it's perfectly legal, it's non-intoxicating, it can be smoked, it smells exactly like the medical cannabis we get in dispensaries. The odor of cannabis is not probable cause to determine that someone is impaired. There's just no reason to allow a search at all. The courts may not have recognized this, but we certainly can. I urge the committee to drop the section that allows the exception for police officers to search based on odor, to search within reach of the driver. Thank you very much.
Excellent. Thank you very much. Questions from the committee? All right, seeing none, thank you both very much. Thanks. So Mr. Love is not here. We'll accommodate him when he gets here, but we're going to switch over to the opponents of the bill, and we'll hear from Mr. Schellenberger. Is Mr. Hills here? Yeah, and then Mr. McCarthy is going to join us virtually. But
Mr. Chairman, Mr. McCarthy, if he's able to go, I won't go because I.
Excellent. Okay, got it. Appreciate it. Thanks.
Thank you. Good afternoon, Scott Schellenberger, State's Attorney for Baltimore County. I hope you all have noticed that I have not testified on any marijuana bills in the last year. I have stayed out of it because I believed in the will of the people, so I have not testified on any marijuana bills in the last year, and that is until now. I'm opposed to House Bill 1071 because it's the courts that tell us what the Fourth Amendment means. We allow that happening all the time. The courts, as you can see by my written testimony, have said that odor is enough to establish probable cause to search the car. Odor plus a joint of marijuana is probable cause to search the vehicle, but very important, odor plus a joint, you can search the vehicle, but not the person. They have already said that, and these cases were passed after decriminalization. Odor is not enough to arrest and do a search incident to arrest. That's already the law in the state of Maryland. Odor is enough for reasonable suspicion to investigate, but it's not even enough for a pat down. So those are the four cases that I cite in my written testimony that already lays out the rules of the road for what the police are doing. And the question was asked, well, how do we regulate what the police do when we're dealing with a legal substance? Well, let's see. Is there a legal substance that the police deal with all the time when people are in their cars? Alcohol. We haven't passed any laws telling the police how they can act and what they can do when they smell an odor of alcohol coming off a person who has been driving. And Senator Smith, you hit it right on the head. They are not pulling people over because they drive by them and smell it. What they're doing is they're pulling people over for a valid reason. Bad tag, speeding, not stopping, could be a minor traffic incident. So then they come up to the window, ask for the driver's license. What I've heard described is the window goes down, the smell comes into their face, and now you have a traffic violation plus the odor of marijuana. And the court has already told us what that officer can do. The officer may be able to search the vehicle. They cannot search the person. They cannot arrest the person. It's enough for investigation, but not enough even for a pat down. They can't even have them right now get out of the car and pat them down. What I propose is that we do with every other issue that we deal with when we're talking about constitutional issues. And that is, this is a Fourth Amendment issue, and we let the courts decide. They tell us what the Fourth Amendment means. We usually don't have the legislature do that. I haven't seen that in other places. I certainly understand the comments about the wiretap statute. It's a very unusual area of the law because it is a place where there is so much privacy in your phone calls. So I believe what we should do is allow the courts to decide, for them to tell us what the Fourth Amendment means with regard to all these issues once decriminalization kicks in. And that's basically how I stand.
Excellent. Thank you very much. I know we have a couple questions, but I'm gonna let there's I see McCarthy, Mr. McCarthy's here, so we'll let Mr. McCarthy testify, and then we'll have open it up for questions.
Okay, good afternoon. My name is John McCarthy. I'm the state's attorney for Montgomery County. To some extent, I would be echoing to a large degree a lot of the points that were made by Mr. Schellenberger that preceded me. I would also note that I personally do believe, as he has stated, this is an issue for the courts. This is a constitutional issue that has been well settled in a variety of ways that limit what the police are permitted to do. My goal, and I actually think it's Mr. Schellenberger's goal as well as any state's attorney, is to reduce the number of guns on the street. I have shared with members of this committee, including you, Senator Smith, during a year in which there were record numbers of guns seized off the streets in Montgomery County, which was 1,203, 179 were ghost guns. I began to look at, and I was asked to look at, the seizures that come out of cars, gun seizures, with the goal being reducing guns on the street in Montgomery County. We have looked at every single gun seizure that came out of a motor vehicle and tried to look at those cases and isolate what was the probable cause, what was the reason it got us into the car to seize guns that were seized in cars traveling along the roads in my jurisdiction. Well, in August last year, 70% of the guns seized out of cars in August last year were seized because the officers got into the car based on the odor of marijuana. In September, it was 86%. In October, it was 75%. In November, it was 69%. In December, it was 85%. In January, which is the last month I have a full month total, it was 70%. If you are serious about reducing the number of guns on the street in our community, giving and allowing the police to have this power and let the courts decide where the proper lines are drawn, that is absolutely essential. And I'll make one additional point, and I know that I've talked to Mr. Schellenberger about this and other members. There is a strong correlation, not only just the mere presence of guns, but guns and homicides. The last 14 drug-related homicides that have occurred in Montgomery County, marijuana was involved. The last 14 in a row. I think similarly, if you asked anybody who is in my business around the state about the relationships about guns, drugs, they're going to tell you that the leading category in which there are homicides is drug-related homicides, and the drug involved, shockingly for most people in the community on the street, it's marijuana. So again, I join with Mr. Schellenberger on behalf of the Montgomery County State's Attorney's Office. I know I have multiple members from my community there. If you want your community safe, you want to reduce violence, you want to reduce guns, you have to oppose this particular bill. Thank you very much, and I appreciate the courtesy of calling me. Thank you.
Excellent. Thank you very much. All right, we are going to take questions from the committee for the state's attorney. So we're going to, I saw Senator Carter first, then Senator Sidnor.
Thank you, Mr. Chair. First, Mr. McCarthy, if you haven't already provided the data that you just described, I'd appreciate you supplying specifics of that data to the committee before we make our determinations. Second, I know that you well know, and Mr. Schellenberger well knows, that the Constitution has long held that the end doesn't justify the means when it comes to the Fourth Amendment. Of course, there are exceptions, but what has been discovered, even if it's true, nevertheless, does not give license to violate the Fourth Amendment. And so I just want to go back to what you talked about, Mr. Schellenberger. I think you were probably referring to the Rashard Lewis case, where the court said that because small amounts were decriminalized and it wasn't able to, you couldn't tell how much someone had, that didn't give license to search. But that was in fact prior to July 1, 2023, where it's no longer decriminalized in small amounts, but legal in larger amounts. And so how would you reconcile that, what you just testified to, with the cases that have held that the intent needs to be in the legislature, I mean, in the statute, the legislative intent? And I'm talking about, as was testified to earlier, when it came to the Desjardins case that referred to the King case, and the Desjardins case said if the legislature intended for the evidence to be inadmissible, then it would have said so. And then it went back to it referred to the King case, which basically said with regard to the DNA statute, that it wasn't expressly in the statute by the legislature. So that wasn't the remedy. But if the legislature intended it, they would have done like they did in the wiretapping statute and made it clear. How do you reconcile the fact that our highest court has already held that these things the intent must be in the statute?
Well, what they have held is the four things that I indicated earlier, and you are correct. I was quoting the Lewis case when they ruled that you needed more than just an odor to constitute probable cause to make an arrest of a person or conduct a search. And that's not going to change. It's only going to, I don't know what word to use, improve to your side of the argument once it becomes completely decriminalized. But the other thing that we were talking about is, there's odor and then there's odor. And I have, I understand the face, that there is an odor that you've heard officers described as I could smell a faint odor of marijuana, whereas you've heard officers testify that it literally hit me in the face. And that's always dependent on the amount. So that's why I believe the courts have to make these decisions. And it's because every case turns on the slight facts that are different. Does the officer come up and said, I smelled a slight odor and the person had a taillight out? Well, there's no evidence at that moment of bad driving. So then the officer might only be allowed to do a certain amount. If the officer saw bad driving and then smelled the odor and it was a great amount, then the Fourth Amendment might allow them to do even more. And what I'm saying is the facts of each case will slightly turn whether it's going to be ruled admissible or a lawful search. And that's how we've decided everything with our court system. And that's why it should be decided that way with this.
Was really an answer. I don't think it was an adequate answer to the question, but I also just wanted to correct you about something. You said decriminalized. I want you to see if you can say legalized beginning July 1, 2023.
I
'Cause
I
that's
can
the
say
intent
in
of
July
legislation.
1, 2023, marijuana will be legalized in the state of Maryland, and that is so.
Thank you very much.
A question for Mr. McCarthy, and good afternoon. I was listening to the stats that you were mentioning as well, and I'm curious. You were talking about them where you the I think you said 70% or an 80-some%. Were you talking about stops that were initiated because of the smell of marijuana, or were you talking about searches that were initiated because of the smell?
Senator, I appreciate your question. What we did is we literally went back and pulled every case in which a gun was seized out of a car, and we read the police reports. I have a gun unit, and that's what they did. And so we were looking at the cases where the probable cause that got us into the car was based on the odor of marijuana. And so when I say 70% for August, reading those reports uniquely from that month, in instances where we searched the car, 70% of the time, the lawful justification for the officer getting into the car was the odor of marijuana.
Well, that's the stop.
You know what, we were looking at the stop is different than how they got into the car.
That's what I'm trying to figure. That's what I was trying to
Yeah,
figure
let
out.
me
The
say this.
statistics is the
We
stop
were-
of the search.
We were reading as, like, I think typically when a car goes riding by you, I don't know you're going to ever stop a car because of the odor of marijuana.
Right, I agree.
There's usually another reason you stop the car, but what gets them into the car is the odor of the Carroll Doctrine, allowing us to get into the car for the purposes of conducting the search. And the Attorney
Search.
General's office, before General Frost left, they did issue an opinion on the legality or the continued legality of the Carroll Doctrine. That was from our Attorney General, did it, not any of the individual prosecutor's office. There is an opinion that's been distributed to us by the Attorney General's office that it was still lawful to conduct Carroll searches, even under the proposed legal changes.
And for us, non-criminal attorneys, what's the Carroll Doctrine?
Well, basically, the Carroll Doctrine is a Fourth Amendment issue. The courts for many years have articulated the legal basis upon which officers are permitted lawfully to seize the interior compartments of motor vehicles, and among those bases has been maybe the odor of marijuana, because we are still policing our streets, for instance, for driving under the influence. We are allowed to, under the Wilson Doctrine, order people out of the cars for the protection of the officer. You can conduct a search if you believe that there's potentially contraband in the car. And as was mentioned by the previous speaker, you know, if there was an odor of alcohol, we might have you step out. Odor of marijuana, we might have you step out to see whether or not you are capable of safely continuing to operate a motor vehicle. They step from the car. There might be field sobriety tests. When it comes to narcotics, there are officers that are trained in detection, and they can have somebody come out and do the field tests uniquely for drug addiction as well.
And would it be your testimony based on the stats that you talked about, that it's the cannabis smell that leads to the drugs? Essentially, I guess is the cannabis industry you're saying that's the driver, or the drug trafficking, that's the driver of the violence that you're seeing in Montgomery County?
Well, let me say this: the one point that I did make, and is actually a fact, in the last 14 drug-related homicides, 12 of them were exclusively over the distribution of pot. They were about pot. The other 2 were about the distribution of pot along with other substances. So the last 14 consecutive drug-related homicides in my jurisdiction are involving marijuana. But by the way, just to clarify, I was in favor of the law being changed, by the way. I was in favor of the legalization I was in favor of the legalization because I thought 2 things could happen. One, I thought we actually might be able to reduce the number of homicides in my county that were drug-related. And 2, I thought we might stem to some degree the demand for guns in the community, both of which concern me. I was in favor of legalization for those 2 reasons.
Thank you very much, sir.
So just to follow up, and make sure it's clear, the vast majority of these stops are for a different reason. Speeding, taillight, tag. So there's a legal reason for the stop. Then when they get up to the window, we're talking about the next step. They widen down the window, you don't smell anything, you give them a ticket. You wind down the window, you smell something, alcohol or drugs, you have the power to take the next step. The question is, who gets to decide how far that next step is? And what I've outlined here is the courts have already put limiting powers when there was decriminalization. And Senator Carter, when there is legalization in July, then we will find out what some of these other powers may turn out to be. But Senator Sidnar, 2 murders that you know about, murder at the Trader Joe's in Towson and a murder recently near the new apartments on Susquehanna and Washington in Towson, both marijuana related. I can echo what my friend in Montgomery County says. Drug-related murders are always over marijuana. And Senator Carter, I'll shock you even more. I am very hopeful that come July 1st, just like Mr. McCarthy, that these drug-related marijuana murders drop and drop down because they will have a legal avenue to get their drugs.
Good, Senator, good.
But that's different than this.
That you're speaking about, that's the one of the university student.
I'm sorry?
That was the one of the university student.
Yes.
Thank you.
I'm gonna go to Senator Washington, then Senator Carter. But you talked about the Carroll doctrine. So, I mean, that's one of the questions the panelists brought up before about, you know, how does that apply on January or July 1st, rather, when you have a legal, you know, cannabis will now be legal to 1.5 and, you know, decrimmed from 2.5 up to 2.5.
Right.
So how does that Carroll doctrine apply? Because you can't I mean, how can you readily discern between a legal amount and illegal, because the legal amount's not contraband.
Right.
And so that's the kind of, yeah.
Right. So the Carroll doctrine, and I meant to follow up on that. The Carroll doctrine was designed decades ago, in which it says you have a lesser expectation of privacy in your car. And the reason for that is because, you know, you have to get a license, you have to get a tag, you got to do all these other things to have your own motor vehicle. So you have a lesser expectation of privacy in your car than you do in your person. And that's why we have that one case where they said you can search the interior of the car, but you can't search the person and pat them down. That's what the difference is. And that's what the Fourth Amendment distinguishes between. So I agree, it is going to be difficult for the courts to draw that line, but we've been doing it for decades, where they draw the line as to what the next step the officer can take and whether it's a legal step or not. And it'll come back to, all right, were you seeing the car bobbing and weaving and you smelled a strong odor? Well, then you'll be able to do more. You can get out of the car. You can do field sobriety tests. There are special police officers called DR-14s that can conduct field sobriety tests for alcohol and drugs. They have special training to do for drugs. So these are some of the things that, you know, we're going to see. But in every other area of the law, for decades, we've let the courts decide because they're the ones that tell us what the Fourth Amendment means. We typically do not put them in statutes.
Thank you, Mr. Chair. Mr. McCarthy, I appreciate your data that you provided to the committee. Can you send that data to us at a certain point so we can see that?
Thank you very much, Senator. I'd be happy to do that. I will send you the data for the 6 months that I talked about. That data was compiled by my office, not by the police, because we had a hand look at the reports to come up with the data. So this is internal data that we created. And the other thing that I think might be helpful is there is the Attorney General's opinion that was drafted shortly after the vote that took place, and the will of the people was that we would make a small amounts of marijuana lawful. But we could, I think, I think that memo was written by a woman named Carrie Williams, who was one of the chief lawyers in the Attorney General's office under General Frosch. I think we should probably send that to you as well.
Yeah, the reason I asked that question for the information, I'm glad you clarified, because it doesn't sound like the police department is keeping that data themselves and looking at that information themselves. And that becomes a major issue for me, at least as a policymaker, because I would love to see what that looks like on an annual basis of how many times we're pulling over people. And the data that you have, I think, sounds like something that we should know. I wonder if there's also data involving searches that occur based solely on odor, and nothing was found at all in that in the car.
May I say, I don't, the data that we look at are data where arrests were made, and we pulled those cases to find out what was the probable cause that led to the search of the vehicle that led to the seizure of the gun. In the cases where there is no arrest, there is no seizure, and a person is let go, I don't have that data. The police don't collect that data. And as you accurately already pointed out, the data that I'm citing is data we compiled ourselves by hand culling through the old reports and reading them to figure out what the numbers were. So I don't think those numbers you are suggesting, Senator, exist. I don't think they do.
Thank you.
So several of us have asked for the data that you referenced, Mr. McCarthy, and I wanted to add to that a question, and if you have any data on this, I appreciate it as well. With regard to the gun issue, the gun offenses, are you aware of charging and convicting under Public Safety Article 5-140 for gun offenses, our gun trafficking statute? If you have any data, or I'd appreciate just knowing if that's something that your office has charged and how often.
I'm going to confess ignorance. You're citing a specific code section. I can't just off the top of my head answer your question. I may be able to find that information, but based on
it's our gun trafficking statute.
It's a what statute?
Gun trafficking. So we have a lot of, charges I see all the time for possession of an illegal gun, wearing, carrying, transporting an illegal gun and the like, but I don't see trafficking charged very often. And I'm just wondering.
I can find out how many times we've charged that in the circuit court. We have data on that. I don't know the information that is obtainable through our case management system. I don't know the answer to your question.
One last question. I know for Mr. Schellenberger, and then I think it was Mr. Rusty Carr. Was that his name? He came in and he set his bottle of cannabis there, and as a demonstration that possession or quantity or whatever doesn't, even a smell coming out, you can't determine how much he has. So and it's my understanding that I guess the courts have also said, just based on smell alone, that one cannot determine the volume or the quantity
Correct.
of marijuana.
Correct. And what the gentleman did would, in my mind, lead an officer to not do anything, because he was very articulate, was not displaying any display of any kind of intoxication or under the influence. He clearly showed how much he had, which was under the 1.5 ounces that you all have decided is going to be personal use. And therefore, based upon what we just observed here today, I don't believe the officer would have the power to do anything else under the Fourth Amendment.
Based on
what we just saw here today.
Thank you.
Thank you, Mr. Chairman. My questions are for Mr. McCarthy. How are you, Mr. McCarthy?
Senator, how are you? Good afternoon.
Good to see you. So the lady from the ACLU said there are no statistics on illegal guns located through odor. So we find out today that that's not the case. You have those statistics, and I know Senator Washington and Senator Carter asked you for those. But I actually kind of want to hear them again, because you went through them really fast. So if you could repeat kind of month by month, what percentage of illegal gun cases are located through the use of odor for the statistics that you provided earlier?
Again, the total number of guns we seized, the total number of guns, across the board was 1,203 guns last year in Montgomery County. 179 of them were ghost guns. Now, in terms of the percentages, I'm talking exclusively about guns that were taken from automobiles. We have hand searched our data beginning in August. So based on guns obtained out of motor vehicles in Montgomery County in August of last year, 70% of the guns seized out of cars were seized because the probable cause that the officer developed that allowed them to get into the car was the odor of marijuana. In September, it was 86% of the guns seized in Montgomery County when they got into the car because of the odor of marijuana. In October, it was 75% of the guns seized in Montgomery County. The officers got into the car because of the odor of marijuana. In November, it was 69%. In December, it was 85%. And in January, it was 70%. So we've had a consistent, the police have reported to for years that it was anecdotally, they would say, look, the vast majority of guns we seize out of cars relate to the odor of marijuana. They would tell you that. The police don't capture that number, Senator. I've now said that 3 times. So we literally hand counted. A woman who heads my gang unit went through and read every report because I think I shared the data with you, at least informally at some point in time. I shared it with Senator Smith. And I believe that we began to try to cull the data because it didn't exist. If there are frustrations from members of the panel about this kind of data not existing, I shared it. And
but now we have it.
Now, well, we have it for a 6-month period, and the only advantage and the period that we're looking at in my jurisdiction is the basically most recent 6-month period. It is it's not ancient data. It's
Got it.
Real in-time data.
Got it. Okay.
Mr. McCarthy, Mr. Hill was nice enough to hand it to me, and I will pass it to the committee.
Got it. So, Mr. McCarthy, the woman from the ACLU testified also, and I quote, "There's no evidence that drug trafficking drives violence." And it sounds like that was also not a correct statement.
That is absolutely, that's absurd. That is absurd. I know Mr. Schellenberger mentioned it, but I've had these conversations in meetings with the State's Attorneys Association. We're all sitting around together and we talk about drug-related homicides in our community. And we have noted to each other for years, anecdotally, it's always about pot. And so may I say that I'm sure I had 3 double homicides in my county the last couple of years over the distribution of marijuana. Go back to whatever county you're from and ask your state's attorney.
So it sounds like the majority of homicides in your county, my county, as well, is driven by drug trafficking and specifically marijuana trafficking.
Well, let me say, may I clarify, Senator? When I gave that number, I'm talking about the homicides that grew out of drug distribution or drug transactions. We have other kinds of, we have domestic.
Sure, domestic, yeah, absolutely.
We have other kinds of homicides as well.
And separate from homicide, is other violence in the community driven by marijuana trafficking?
Yes, and it's one of the reasons I support the legalization of marijuana. We have shootings, we have robberies that fall short of homicides every day in this state. So there is a tremendous amount of violence and a demand that drives the demand for guns because people are out there know that it is a violent world, and to protect the valuable money and drugs they have, they get guns.
Understood. So Mr. Murphy testified to something. I appreciate the honesty with which he testified. It was really helpful that if someone had a distribution amount of marijuana in their trunk, like 100 pounds in the trunk, and the odor was emanating from the trunk, under this bill, the police officer would not have access to the trunk. Have you prosecuted people who have kept large quantities of marijuana in their trunk that where those prosecutions would not be possible under this bill?
Well, I think that there's probably just about every kind of scenario. I am sure that we have prosecuted individuals who were traveling along the highway that had large quantities of marijuana in all different compartments, including trunks of cars. I'm not speaking about a specific case, but it's clearly happened. I can't
Got
tell
it.
you how many times, but it certainly has happened.
Okay. And then I want to explore this idea that the chairman explored, that the bill would, where it's clear that someone might be dealing because of large quantities of marijuana associated with large quantities of cash. It seems like the reading of the bill is that because the amount specified is not the legal amount, and the amount of cash is unspecified, that this could lead to dealers, the very people causing the violence that you referenced, to be let out because of this legislation. So is your reading the same as some of our reading, that the bill, if this bill were to move forward, it would need to specify that the amount be the legal amount, and that the cash be some kind of reasonable amount of cash, as opposed to, 100 pounds of weed and $10,000 on the front seat?
I don't mean to be evasive, but I would
Yeah.
probably back to an argument that's already been made to you. I would leave that issue to the courts. I don't think that this is a matter for the legislature. I think this is a matter of well-established constitutional principles. And I think that whether or not this is constitutionally permissible or admissible under the Maryland Declaration of Rights, those are matters for the courts. I do not think it would be it's an appropriate area for the legislature to involve itself.
So Senator,
And
I
then
don't want
I
to,
have one more question.
I get an answer to your question.
Okay, and then why don't I get this one last question for Mr. McCarthy? So, Mr. McCarthy, going back to the DUI issue, it's clear that the proponents of the bill seek to allow a DRE to come to the scene if the person was swerving or otherwise the stop was related to driving under the influence. But it's also clear that the proponents, if the stop is unrelated to someone being under the influence, but the person, after the stop, the odor indicates that the person may be under the influence. Like for DUIs prosecuted out of your office, I assume the majority involves some type of indicia for the stop, but do you also prosecute where the stop was unrelated to the intoxication, but the intoxication was learned when the window was rolled down? Is that something your office will prosecute?
Somebody could run a red light, not stop. I mean, it may not necessarily be because they're weaving, or there are a variety of different ways in which an individual could be stopped. And then the marijuana is the second thing that you become aware of, not the primary thing, nor even impairment. They're doing good policing, trying to make sure that people are operating vehicles safe.
Mr. McCarthy, we can't hear you well. Is there something, can you adjust the microphone or?
Can you guys hear me? I'm moving closer to the mic.
There you go.
Is that better?
Right. That's it.
It's much better. Yeah. Let
Okay,
me try that.
I didn't mean to do that. I didn't mean to speak too low, but
Let me try the question one more time. Under current law with regards to alcohol, if the stop is unrelated to the alcohol, but the officer then learns after the stop that the person is intoxicated, could that prosecution move forward under current law?
yes.
Got it. Mr. Chairman, I've taken up a bunch of time, but I was hoping, I know Ms. Braveboy signed up for informational purposes, and I was hoping I might be able to ask her a couple questions, if that's okay with Ms. Braveboy.
All right, Ms. Bradway, I know you're next up anyway, so you want to come up, and then we have Mr. Love is we'll bring up the rear.
Was she going to testify, or she was?
Were you testifying? You just here for information, or you come? Sure, yeah, absolutely. And then we'll have Mr. Love come up afterwards.
Good evening or good afternoon, Mr. Chair, Mr. Vice Chair, and esteemed members of the Senate Judicial Proceedings Committee. And I'm sorry, it's been a long day for me, but it's great to be here with all of you. I'm just here for, I signed up for informational purposes because I wanted to make sure that everyone understood what the impacts of this legislation might have on gun seizures in Prince George's County. So currently, as of 2022, and I got this information directly from our police department. There were 1,237 illegal gun arrests, and of that number, 543 were as a result of searches and seizures based on the odor of marijuana. So it is a pretty significant number in our county. In addition to that, I can tell you, since I've been state's attorney, pretty much 100% of our drug-related homicides that sometime range from roughly a quarter, in some years a third of our homicides are a result of drug transactions gone wrong, and 100% of those are related to marijuana. So I, like many of you, am concerned about public safety. I'm also very sensitive and recognize the disproportionate contact with minority populations. In fact, my office successfully prosecuted the officer involved in the incident that Mr. Ruff mentioned earlier. But my biggest concern with the legislation, or something that I think it's important for you all to understand, is that once we pass legislation here, we have to go back and train and inform our police officers on how to conduct themselves when interacting with the public. And I believe that some of the language in this bill, as was mentioned from the proponents and the opponents, is somewhat ambiguous. I believe that the courts have provided guidance to us in prior cases like Pacheco, Robinson, that really helped us in our training of our police officers on pretty much what they can and cannot do on these traffic stops. And so we think that the courts really can provide better guidance to us than, honestly, sometimes the legislature does. And we understand you all are trying to create policy here, but we are enforcing the law. We are dealing with individuals' constitutional rights, and we want to get it right. We want to get it right because we don't want to bring cases where we're going to be litigating motions because we're unsure of what the legislature intended. Generally, the courts give us specific guidance that we can follow and that we can train our police officers on. So that's, I just wanted to provide that as information. And my senator from my county just arrived, and just to let you know, I let everyone else know that in Prince George's County, these are numbers coming from the police department. So there were 1,237 illegal gun possession arrests. And of those, 543 were based on the search and seizures based on the odor of marijuana. And I also mentioned that pretty much all of our drug-related homicides are a result of marijuana transactions.
I'm probably feel like I'm beating a dead horse on, but I'm trying to understand. Just you smoke marijuana, or there's a smell of marijuana. That doesn't necessarily mean that someone's impaired, right?
That's correct.
So what would then make you want to take the next step? Or what are you hearing that the officers are saying would make them then take the next step to then conduct an invasive search?
Well, again, the courts gave us guidance under Pacheco that the odor of marijuana is enough to search a vehicle for potential illegal contraband. Now, this is before the legalization of marijuana.
So you're still using, so our state's attorneys using old doctrine then?
Well, the legalization takes effect July 1st, I believe, of this year.
But aren't people still allowed to smoke it legally if it's medical?
If they have a medical marijuana card, they typically will provide that documentation and information to the officer.
So I have a medical marijuana card. I take a whiff in the card. Police come up. But they ask, do you have a card now? Before they do a search?
Honestly, I don't know if we have any members of law enforcement here that do those stops. I don't know the answer to that question.
Thank you.
I just want to enter a PSA real quick. So we're going to end this hearing shortly here. I know we have one more witness testify, but there are several members of the House Judiciary Committee that need to get back to vote. And they've been waiting a very, very long time. So we're gonna go ahead and we've got one more witness come through. One thing for me, for the people that have been involved, like the actual victims of gun violence, it would be interesting to me to know, you know, what are those, what's the demographic information on that, the ones that are associated with cannabis, but then also the stops too. You know, those stops and arrests, I'd love to have that information disaggregated so we know not only the you know, the demographic data for the people that are arrested, but also the results that you're talking about. You know, what do those people look like? And
Yeah,
I should defer to Senator Washington. He's the data guy. So
Yeah, and look, I mean, it's Prince George's County.
Yeah.
Our county is a minority county. The majority of our arrests are of Black people. The majority of our victims are also Black people as well. I mean, that's just the reality
no,
of the
got it.
demographics.
Yeah. So Senator Carter's got the last question, and then we're going to move on to Mr. Love, and then we are going to go to the House Judiciary members who have been waiting very patiently.
Quick question. So I'm curious from Mr. McCarthy and Mr. Schellenberger, who I saw him with the paper, like he's going to pass out some data that we've asked for, and even State's Attorney Braveboy. Can you be more specific, like how many traffic stops? We'd like to know that. We'd like to know. You said that odor is the reason for the initiation of the stop.
I didn't say that odor was the initiation for the stop. The stops are typly traffic stops.
Right.
And then
But so the
odor of
marijuana
marijuana
there.
comes into play when there is contact with the driver. That's
Right.
Yeah, so no one's stopping
it's
anyone
not
because of odor. They're stopping them for other reasons.
That's what I was getting at. So the cause of it, the way that it sounded was that out of the 1,237 stops, the other number that you gave was the initiation of the stop was based on.
No,
the
I said the initiation of the search.
Okay.
The search and the seizure. was
How
based
do
on
do you
marijuana.
have data on how many total traffic stops?
I would have to get that from the department because again, we get the cases, right? So we get those that result in arrest, not necessarily just because someone was stopped. But we're happy. I'm happy to try to get that information for you. And again, I'm not here to say this is a bad bill. I'm not here to say it's a good bill. What I'm saying is that I have to at some point train the officers in Prince George's County on what the new law looks like. And what I'm saying is that case law has provided us with much stronger and better guidance in the past to determine how we should proceed, what's lawful, what's not lawful, than sometimes legislation, no matter how well-written it might be or well-intended it might be. Again, I live in Prince George's County. I recognize that there has been a disproportionate contact with minorities. And that's why the legislature has moved in this direction. So I'm not I'm not here to tell you that we should not have certain standards or we shouldn't legislate in this area. All I'm saying is that when it comes to what is a lawful search now based on the fact that marijuana is legalized, that level of guidance coming from the courts would prevent, I think, disproportionate even application of this law around our states, because many courts could interpret some of the language very differently depending on where you are in the state. So in Prince George's County, it may be more restrictive in how what the courts might allow officers to do in terms of searches based on the language, especially around the searches incidents to DUI or DWI stops. That language in this bill to me is a little it's open to interpretation. So those are some of the.
We do have to end this colloquy because we have 5 members of the. It's good.
With all due respect, I don't agree with that at all. I don't think this bill does anything at all to interfere with the search incident to a lawful arrest.
No,
This
not
bill
to it.
is only
But-
talking about the
but-
initiation
They're voting on Senate bills.
based on that. I just want to be clear about that.
Okay, but I want you to, if you look at the portion that talks about the, what level of search you can do based on DUI or DWI stops, it is, I think, and I'm just trying to look up the exact language, but it's like, I think there's some language about reasonableness or reasonably accessible to the driver or something like that. There is, and I apologize, I wish I had the bill in front of me, but there is language that I think is open to interpretation by the courts.
Excellent. Thank you very much. Appreciate it. All right, next we'll have Mr. Love come up, and then we'll get started on this, the House Judiciary members, so they can get back to their voting session.
All right, good afternoon. It's clear that law enforcement has been extremely reliant on cannabis prohibition as a crime fighting strategy. The notion that drug trafficking is the primary driver of violence is an assumption that is not backed with comprehensive data. There's now data emerging both in the state of Maryland and around the country that shows that drug trafficking actually accounts for much less of the violent crime that exists in our communities. If you look, for instance, at the Maryland Sentencing Project in 2019, only 24% of gun crimes were associated with drug offenses. I've mentioned previously to this committee that Monty, an agency in Baltimore City, looking at the Western District, one of the most violent districts in Baltimore City, in 2018 and 2019, only 14.6% of those homicides came as a result or were related to drug trafficking. Even if you look around the country, and I wish in this committee we had the opportunity to talk more comprehensively about anti-violence strategy. You look at Newark, for instance, has actually been one of the greatest success stories around addressing violence. And they found in Newark that 62% of the homicides were relationship-based. So they retrofitted their law enforcement strategy and their approaches to looking at the way to build relationships in communities to prevent violence. One of the things we do have data for is the way in which law enforcement has interacted with Black folks in ways that have led to violence, brutality, dehumanization. That data now, given all the various reports that I quote just about every time I come up here, and it is often not refuted, that is the evidence that we have in terms of the impact that this will have. The idea that the crime fighting strategy relying on cannabis prohibition and looking at the fact that even the state's attorney from Prince George's County said that in her county, 1/4 to 1/3% of the homicides are related to cannabis, where that means that the 2/3 or 3/4 of violence is not related to that. Even the data that was given by the Montgomery County State's Attorney, seizing guns doesn't necessarily correlate to actually stopping violence. I would want information as to how many of those seizures were related to folks who were repeat violent offenders, who were people who needed to be put behind bars. That would be actual data that would mean that this is an effective crime fighting strategy. If they had comprehensive data on this question, they would be able to produce it. Instead, we have people saying that their office studied it, but we don't have comprehensive data. I've cited the best data that I think exists on this question.
Excellent. Thank you very much. And thank you for your patience. Questions from the committee? All right, seeing none. Thank you, Delegate Crutchfield. That'll end the hearing for House Bill 1071. Well, one down, several to go. Can I go, please? We'll start off with Delegate Simpson with House Bill 362. Welcome.
Thank you very much. I think we have definitely shown that we could have like a joint committee on judiciary between you all coming over there, us all coming over here. So I thank you very much. I'm going to make this super, super brief. I hope for a favorable report on 362. This is, about our wiretap statute. I think most of us would agree, since I think every single one of you I've seen with a phone. All of our state issued computers all have the capability of doing recording. And I think we would agree that most folks in Maryland would be very surprised to know that we have a two-party consent for being able to record someone else, when there are 38 states that have one party. And this bill doesn't change that. It just has one word. It changes it from a felony. I hope we would agree that recording somebody would not be at the level of a rape or a murder. So it just changes it from a felony to a misdemeanor. And that's it. I'd love to have a favorable report so I can go back and vote on all of your all's bills.
Excellent. Appreciate it. Questions from the committee? Seeing none, thank you very much, and thank you for your patience.
Thank you.
Excellent. Thanks, Delegate. All right, with that, that'll conclude the hearing for House Bill 362. We'll now move on to Delegate Young with House Bill 980.
Basketball. Thank you, sir. Oh, yeah. Stop playing with me.
That was the good question.
Oh, definitely wasn't the mayor. No. Colleagues, members of the Senate, Mr. Chair, Mr. Vice Chair, it's a pleasure to be here. Delegate Young, from District 45, East and Northeast Baltimore, here on behalf of House Bill 980. The bill is very simple. It simply says and recognizes that with legalization, we should probably stop violating folks with regard to parole, probation, and pretrial release for merely the use of cannabis. What the bill asks for after we amended it is simply that a judge at the time of setting your pretrial release circumstances or rules, or at the time that they set your parole or probation conditions, that's the word I was looking for, that at that point, they would have to make the determination that you cannot use cannabis, similar to how we do with alcohol. And if they don't at that point, then subsequently, they would not be able to come back and violate your parole or probation merely for the reason of having used cannabis. So again, it's just a matter of recognizing that we are legalizing and ensuring that if there is a circumstance that a judge decides this individual, for whatever reason, shouldn't be using it, they just make that decision when the conditions are set. And that's it.
Excellent. Thank you, Delegate Young. Questions from the committee? Seeing none, thank you very much. That'll conclude the hearing for House Bill 980. Get well soon. All right. Next, we'll hear from Delegate Phillips with House Bill 1032. Welcome.
Mr. Chair, Mr. Vice Chair, thank you very much for allowing me to present Bill 1032. And I will be relatively brief. And I'll start with the fact that the bill passed the House 133-3, and it came out of committee 21-0. This is a bill that I think makes a great deal of sense. And all it does is it says we want to protect minors who are victims or witnesses in the criminal court system. And I'll give you some background about how this came to be, and it came to my attention. There was a situation where a parent had said to their child that if they went through and shared their experience, the person was being molested as a youth. If they went through and shared their experience, their name would not be placed in a public record. Went through the process, they acknowledged it, went through, and the individual for which the had abused the child was actually prosecuted. Lo and behold, come back later to find out that the youth's name was actually in the public record. One of the things that has become very apparent, shortly after that, I had a parent reach out to me in my office and say that their child was being catfished and had received a notice from an individual. They responded and gave that individual some pictures that were inappropriate and were then blackmailed, basically. This is a 16-year-old. Parent reached out to me and said, my child does not want to participate in the criminal justice system because they don't want their information to be publicly available. This is becoming an issue for our children. They don't want to participate in the system because they don't want their name there. Today, the law requires that the state's attorney, unless they request otherwise, place the child's name on the charging documents and in other court-related materials. So for that reason, we're asking you that this not be a may be redacted, may be removed, but it shall be, allowing for provisions for other persons in the system, defense attorneys, defendants, court personnel, to get that data, but that data would not be readily available in the public. That's all this bill does. So we ask for a favorable report on 1032.
Thank you so much. Senator Washington has a question.
Thank you. Delegate, were you aware that this bill was voted unanimously? I think you said 133-3, but it was voted.
133-0. I'm sorry.
Correct,
Thank
yeah.
you. Thank you for correcting me.
You got it. No problem.
Yeah. Thank you. 21-0, 133-0. There you go. Thank you.
Lots of statistics
Lots of
in
statistics.
today's
We
hearing.
got statistics all day today. Okay.
Any further questions? Thank you, Delegate Phillips. Really appreciate you being here. Oh, I'm sorry, Senator Sidner.
Just wanted to make certain, this bill, it would capture all kinds of records. I mean, you're talking police records, court records. I mean,
Public
covering
records.
everybody.
It should be the all public record, but those persons involved in the process, right, would have access to those records.
Okay.
There's actually, this doesn't go as far as the federal courts. The federal courts basically says that no one involved in the process can share that information with anyone. It's completely redacted. So we're just trying to somewhat catch up with what the.
Oh, no,
federal
no,
courts-
I'm certainly out, a few years ago, and I think I shared this with you. I championed a bill that was for juveniles who were involved in the commitment. So I mean, you certainly want to protect witnesses. So thank you for the bill.
Thank you. Thank you to the committee.
All right, let's as Delegate Phillips, it looks like we have one more question from Senator West. Now, Senator West, you may have come in after we said that the delegates from Judiciary have to go back to vote on our bills. But if you, but please, if you have a
And
quick
I'm gonna be kind to your bill.
I'm gonna refrain from asking a question. Thank you.
All right, we'll get that one asked offline. Thank you, Delegate. Appreciate you being here. That concludes the hearing on House Bill 1032. We'll now move to Delegate Valentine. Hello, Delegate Valentine. Thank you for joining us for House Bill 1175.
Thank you, Mr. Vice Chair. I'll start by saying that this is not a cross-filed bill. The reason for that is when I was approached at the beginning of session about introducing this bill, the Senate introduction date had already passed, so that's why it is only in the House form. For the record, Delegate William Valentine, District 2A, representing portions of both Washington and Frederick County. I'm before you today to present House Bill 1175. This bill would allow individuals to file a petition for expungement of criminal records based on a conviction of certain misdemeanor-related hunting offenses. This bill is a reintroduction of House Bill 1298, which was presented and passed in the House in the 2022 session. As this committee is well aware, prior criminal convictions have been a subject of much debate in recent years, and they can pose challenges to individuals upon completion of their sentence and payment of fines. Natural resource offenses are no different. This bill seeks to ensure that those individuals convicted of specified natural resource article statutes have the same ability to expunge records of those convicted of other offenses listed in other articles of the criminal code. This legislation was passed earlier this month in the House by a unanimous vote of 134 to nothing, and I respectfully request a favorable report and would answer any questions you may have.
Delegate Valentine serves on Judiciary and similarly has to get back, but any questions for this witness? All right, good bill, no crossfire, but I believe we have passed this in the in previous years. Senator Bailey had this bill.
Yes.
And all right, thank you, Delegate Valentine.
Thank you.
We'll now move to Delegate Terrassa.
All right, thank you, Mr. Chairman and members of Judicial Proceedings. I thank you for this opportunity to present HB 336 Courts, Expert Witnesses, and Letters of Exception. For the record, I'm Delegate Jen Terrassa. This bill may sound familiar to some of you because it is a reintroduction of a bill from last year. Actually, I've been working on this since 2020. This bill, so last year's bill, HB 863, passed the House, and the contents were then amended onto a different Senate bill, but unfortunately we ran out of time on sine die. So I brought it back this year in the same posture. This year it came out of committee unanimously and passed the House 133 to 1. I think I'm right on that, but I'm happy to be checked on that. The problem this bill addresses is that under existing law, it is extremely difficult for defendants to present expert testimony challenging the drug evidence presented against them in court by the state. And there's a lot more information in my written testimony, but just to be brief here, happy to answer any questions. Essentially, under the existing interpretation of the law, defendants seeking to have an expert testify in court after reviewing an analysis performed by the state lab must get the state's permission, which is, from my perspective, a clear conflict of interest. So what it does is it prohibits a court from requiring an MDH letter of exception, that's the state's permission letter, in order for an expert for the defense to be able to testify in criminal proceedings challenging the state's expert data, opinions, interpretation, or conclusions. Just reviewing the written report, not actually going into the lab. I think that's an important piece, or handling evidence, not doing that either. HB 366 once again has the support of the Public Defender's Office and the chemist and forensic scientist Ben Streifel, a constituent of mine who brought this to my attention. I respectfully urge a favorable report.
Thank you. Delegate Terrassa is not on judiciary, so if people have long questions.
So you can ask me as many questions you want. I already missed my vote.
All right, seeing no questions, thank you, Delegate Terrassa, for joining us here today.
Appreciate it. Thank you.
We'll now move to Delegate Atterbury's HB 1176. Ms. Twigg is here testifying on behalf of that legislation.
Hi, all. All right, thanks for having me. My name is Elizabeth Twigg. I'm the Chief of Staff for Delegate Vanessa Atterbury, here to testify on her behalf for HB 1176, which passed the House 127-9. So this bill would require local jurisdictions to create voluntary 911 registries to alert first responders of certain behaviors, diagnoses, and certain traits that a person may present during certain encounters. For example, this could bring attention to an individual's sensitivity to loud sounds or sirens, whether they're blind or low vision, deaf or hard of hearing, have dementia or PTSD, so that those first responders can respond to that scene appropriately. I'll mention that individuals themselves, parents of minor children or guardians of adults, are able to register for this program. I'll emphasize, though, that it's completely voluntary, and many counties are doing something like this already, which is why we came up with this idea. Delegate Atterbury used the system that's currently working in Howard County as an example. It's been successful for well over a decade. So this bill, we know it doesn't fix a lot of issues and concerns that include more training for police and for first responders. It's just another tool in the toolbox to enhance those interactions with people and their first responders. I'll mention that we've been working with a lot of different groups to address certain concerns, and we have amended it several times in the House to address confidentiality, liability, inclusive terms, and fiscal costs. I'll touch on each of those briefly, but to make sure that the information is confidential, folks will have to re-register themselves annually, and they'll be automatically removed after 1 year of no contact. And also, their information only exists in CAD, which is the computer aided dispatch system, and it's only available to those 911 dispatchers. As far as liability, we worked with MACO to address previous concerns and remove the liability of first responders and the 911 centers. We worked with National Federation of the Blind, Maryland Association of the Deaf, and developmental, I'm losing it, DRM, what is that? Disability Rights Maryland, sorry, to make language more inclusive and address those concerns. And finally, as for fiscal cost concerns, a similar bill was drafted last year in which counties did respond, and such systems could be implemented with little to no additional cost. For example, again, the Howard County program was absorbed into the already existing call centers and has resulted in no additional cost to the county in the last decade. So I can try and answer any questions you have, but there's also Rachel London here from Developmental Disabilities Council and Andy Culp from the ARC, Maryland. Thank you.
Thank you so much for being here. Any questions for Ms. Twigg? Senator Carter.
Very much, Mr. Vice Chair. So I definitely appreciate the spirit of the bill, but in looking at the end of the bill where the liability was struck out, I do have a bit of a question because it seems to me that one of the purposes of the bill is to ensure that law enforcement or first responders are aware that someone might have, you know, some type of disability or other characteristic that would caution law enforcement how to proceed. For example, if they're screaming at someone who's deaf, and they would know from this that the person is deaf, and so the person is not being unresponsive because they can't hear them. So this is supposed to alert them to that. So now my question is, if they should somehow brutalize that person because they think they're not responsive, would this bill actually cause more harm by eliminating their ability to be liable for that? Because the issue, like one of the standards is they knew or should have known. And by this registry, if they're on the registry, they should know. Do you understand what I'm saying?
Yes, and I believe that Mako's amendment, which we adopted, would remove any liability for the first responders if they did not follow the protocol that the flagging system alerted them to. Oh, okay.
Wondering if there's this is somehow, make it more difficult.
Our aim is definitely not to make it more difficult. It's just another tool in the toolbox so that the first responders can know what sort of traits and behaviors they might expect at a certain scene. I don't think I understand your question, Senator. I'm sorry.
That's okay. We can take it offline or.
No, I get it. It's just that the absolving of liability because they didn't comply with this, to me, it to some extent might fly in the face of the purpose of it. And then also, I would hate to see it extended beyond the purpose of the bill to immunize them from the liability they might already have. So that's all I was asking, but we can talk about it offline.
Thanks.
Great. Any questions for Ms. Twigg or any of the witnesses for informational purposes? All right, seeing no questions, raise your hand if you have a bill in Ways and Means. That's a joke. Thank you so much. Thank you so much. Well, now is Delegate Moon here? Okay. If he is actively walking across, we will wait for him. So we'll just take a 2-minute break here. That was the quickest 2 minutes. Delegate Moon. House Bill 135. Take your time, get settled, whatever time you need.
Sure. 2 minutes is an omnibus bill.
But 2 minutes, we don't time people over here. You guys time us.
Oh, I see.
Maybe we should.
I'm going to take my time then.
Change that around.
Advantage. Good afternoon, everybody. House Bill 135. This is an omnibus bill. It came in much simpler and it came out much thicker. So I will try and do my best to very quickly explain what it does and why we did it. So the bill, as introduced, sought to repeal 2 mandatory minimum sentences that will exist on the books in Maryland regarding high volume cannabis dealers. I brought this bill in cross-filed with the chair of JPR because I was concerned that post legalization, we would start having quite a number of people who, because of the limited number of licenses we're issuing, will be buying cannabis legally in one part of the state and flipping it back off the books in another part of the state. And why would they do that? Well, I'll tell you, I've got 3 dispensaries near me. They're all on the DC border. So no one's going to the north of my district. Same thing in Ocean City. I think they've got the dispensaries and no, you wouldn't find them elsewhere in Worcester County. In Garrett Park or Garrett County, I assume you're going to see the same thing. People are going to go to population centers. And so I think for some time before we see licenses expand, you're going to have a lot of what we call this gray market activity. We already have it under the medical system, and I think it's going to grow as it's done in every other state. So the question is left for us. with these high volume cannabis dealers is a mandatory minimum sentence, an appropriate sentence post legalization. So there are two of these. One is the volume dealer, and that's 50 pounds. You were a participant in a 50-pound marijuana operation, and it's 50 pounds over 90 days. That's what the code says. That currently gets you it's a felony mandatory 5 years. The other mandatory is for the kingpin, and that's the organizer of this 50 pounds in 90 days cannabis operation. And that's currently a 20-year mandatory up to 40 max. And so the bill as introduced sought to get rid of those two mandatories. It makes the lower one it takes it from what we passed, takes it from a 5-year mandatory felony to a max 10 misdemeanor. So you could get more, but you're not getting the mandatory, and it downgrades it from a felony to a misdemeanor. On the kingpin, that's currently a felony mandatory 20, and we changed that to a max 20, and it remains a felony. So here's where things get wacky. We did not put a resentencing provision into this bill. And so this was just a prospective change. If you were currently serving a mandatory for these offenses, you were stuck. And so in trying to loosen that up, this is where the bill started expanding. So we went ahead and put in resentencing for these folks. They get to try, and they get to try again after 3 years if they're rejected. And then we heard some complaints from law enforcement who really didn't like this bill, and it sounds like they still don't, about the presence of firearms in the illegal drug trade. And so some firearms offenses came into the bill. Now, I know you all were looking at adding time to some ordinary wear carry violations. And so this bill instead took more of a surgical focus and tried to take a look at, I guess, aggravated weapons offenses. And the ones this bill focuses on are the commerce of sketchy guns, as I like to call them. So they either have a deleted serial number, they're stolen, or they were manufactured without a serial number altogether because they're a ghost gun. And so these are likely suspects for crime guns. And these are guns that have circumvented our licensing, background check, and otherwise our identification process. So these offenses were all made into felonies. We did not change the sentence. They went from a 5-year misdemeanor to a 5-year felony, with one exception. We have the ghost gun law, so guns without serial numbers. We have the stolen guns law, and there's this old law that talked about guns with deleted serial numbers that remained a fine-only offense in the code. And so we made that the same as the ghost guns and the stolen guns. All of these are 5-year felonies to keep this category consistent. Now, since we took that expansion to balance out the bill, we started really balancing out the bill. And the next category we brought in was regarding volume crack dealers. And the reason for this is in 2016, we tried to fix the inequity with who got a mandatory minimum sentence for volume drug distribution. In those days, it was about 448 grams of cocaine made you a volume dealer subject to these mandatories. But if you were doing crack cocaine sales, 1/8 of that landed you with a mandatory. It's only 50 grams for crack cocaine. So a number of years ago, we changed that and made them the same. Both 448 grams triggered a mandatory. But again, we didn't do anything for people who were stuck with the previous prison sentence. We made this a prospective change only. So in 2019, Delegate Dumais had a bill to clean up some of these JRA omissions and to give those people sentenced under the old volume crack dealer statute a way to get out. We passed this in the House, and you senators did not return the bill back to us. And so you left the volume crack dealers in prison, even though they were no longer eligible for a mandatory. We've put them back in this bill and are sending it over to you again for a fresh look this time with these gun felonies attached. And the last component to this bill relates to clarifying that the criminal prohibition that remains on cannabis production does not apply to things like producing brownies. This was a Delegate Grammer had this bill, so we threw it into this omnibus. So there you go. It's a multi-part modernization and update to illegal drug and gun trade penalties in Maryland. Man, I'm happy to answer any questions. I know basically everyone hates the bill now. I took a look at the testimony list, and they all are pointing to different portions of the bill they don't like. So that also means they all have portions of the bill they do like. And so I think that's what happens when you do an omnibus bill. But we voted this set of amendments together at one time and took the bill as it is. And that's how it's before you today.
Thank you, Delegate Moon. So I've been informed that Robert Hill is actually testifying in favor of the bill. So unless you have to get back, are you guys done with your?
We're voting on some very insignificant Senate bills at the moment, so I don't care. I don't need to get back anywhere.
Call Mr. Hill up and have him testify in favor, and then we'll take questions for the favorable proponents and the sponsor. Absolutely. State's Attorney, we have you down as favorable with amendments. Please come up and you got it. You are welcome to testify.
So thank you so much, Delegate Moon, for this very important bill. And thank you so much to JPR for hearing this bill. Good afternoon. I'm Aisha Brayboy, State's Attorney for Prince George's County. This bill would provide prosecutors with the ability to hold individuals accountable for illegally distributing large amounts of marijuana. However, they wouldn't this bill would not burden these individuals with a felony conviction. We all know the collateral consequences of a felony conviction. And so we are very supportive of this move now that marijuana is legalized in the state of Maryland. The part that we really appreciate about this bill is that it continues to give us the tools needed to prosecute volume drug dealers that are dealing with other types of drugs. And one of the reasons I wanted to come here today is to talk to you about how fentanyl has impacted our county, Prince George's County. In 2021, there were 133 overdose deaths, and 119 were related to fentanyl. In 2022, there were 94 overdose deaths, and 75 were related to fentanyl, and 7 of them were juveniles. And in 2023, so far, we've had about 17 overdose deaths. For those that have been closed, 7 of them are fentanyl related, and 1 of them is a juvenile. So we have a lot of work to do around the issue of drug distribution. This bill does not prevent us from continuing our efforts in that way. And so what it does is it balances some of the past discriminatory practices of our justice system and how we treated crack cocaine and powder cocaine. And so I think it does, in fact, make our laws fairer and more just, while continuing to give prosecutors the support we need in order to go after those who are dealing the most dangerous drugs in our community. So thank you very much.
Good afternoon, Senators. Robert Hill on behalf of the Montgomery County State's Attorney's Office and John McCarthy. You know, when you look at these bills, as Delegate Moon said, it started off as a thin one and then it came back thick. I initially signed John and myself up as unfavorable on this, and it was only on one issue, and it was my fault because I misread a bracket. What I was concerned about was it looked, on initial view, it looked like it was including fentanyl, and of course fentanyl is just absolutely the plague of our current situation. And I looked at it again, realized it wasn't there, but it was too late to sign it favorable. I would just say this, that we do not have any opposition to the change related to volume dealers and kingpins with respect to marijuana. We recognize the reality of where the law is going. So we have no problem with that. We have no problem with the reconsideration for cocaine base persons that were convicted before 2017. And I would also note that and I believe this comes from State's Attorney Ivan Bates, this particular legislation relating to ghost guns in the public safety article and possession of stolen firearms and those that are not serialized. We're happy with that as well. So just wanted to clarify that we are in favor of this bill, and thank you, Delegate Moon. Thank you.
Excellent. Thank you, Delegate Moon. Questions from the committee? Seeing none. All right, we'll move on to the next panel. Thank you very much. All right. So have we had that was the last one?
Yes.
So let's then we'll switch to the opposition panel. So Mr. Schellenberger, Miss Emanuel, is Devon Love. Is Heather Warnken still here? And we'll start off.
Thank you so much. Scott Schellenberger, State's Attorney for Baltimore County. Delegate Moon, I very much appreciate you trying to reel me in with the changes in the gun laws. Very clever. But it didn't quite get me there all the way. We just spent an hour and a half in which a great deal of the testimony was about how marijuana leads to gun deaths. And now we're going to suddenly give marijuana dealers breaks. And I don't mean just regular marijuana dealers. We're talking about kingpins. 50 pounds of marijuana is 530 times the amount of what you all decided was the legal limit. 530 times. I did a little bit of research, and I hope you look at my testimony. I showed you how much, with a picture, 50 pounds of marijuana is. It's an incredible amount of marijuana. And after I Googled a few things, you can make 453 joints with a pound of marijuana, which means 50 pounds of marijuana, you can make 22,650 joints. They're big joints. This is not having anything to do with a dealer who is supporting their own habit. And that's what we used to talk about. Oh, they're only selling it because they're supporting a habit. That's not what this bill is about. That's not what these amounts are about. And therefore, lowering the sentences, changing all this does really not make sense, particularly when we have just finished in the other bill talking about the combination of marijuana, guns, and murders. And I didn't get to weigh in on that, but Mr. McCarthy, in my experience, is very much similar. I very rarely see people kill people over any drug except for marijuana. And the people who are carrying the guns are the people who are dealing with large amounts of marijuana because they need to protect themselves. So I don't think this is a place or a time to give them any breaks. In addition, the motion for modification on all of that will bring us back into court with a great deal of cases. The idea that anything before 2017 get an automatic motion for modification, I don't think is a good idea also. So for all the reasons in my written testimony and what we talked about earlier in the other bill, and for what I've just recently stated, these are great large amounts of marijuana and they should not be given any type of breaks. Thank you so much.
Hello. For the record, my name is Yanetta Emanuel, Public Policy Director with the ACLU of Maryland, here in opposition to HB 135, unless amended to strike out the provisions in the bill that seek to reclassify several firearm offenses to felonies. While there are some parts of the bill that we do support, as amended, this bill will have no real impact on reducing violent crime and will only increase the opportunities for the state to leverage felonies against innocent people during the plea bargaining process and expand the category of offenses that could trigger sentence enhancements. First, no evidence indicates that public safety benefits increasing sentence lengths. Indeed, evidence shows that the more severe sentences do not deter crime more effectively than less harsh sentences. Second, there's a commonly accepted practice by law enforcement and prosecutors of focusing on minor, lower level offenses like illegal gun possession instead of actual violent crime, which has time and time again proven to be ineffective in actually reducing violent crime, and we urge this committee to seriously question that practice. Comparing Baltimore City numbers from 2019, the year with the most homicides over the past 30 years, and 2011, the year with the least murders during the same period, proves this. In 2019, in Baltimore City, there were 348 murders, 2,203 gun seizures, and 1,161 weapons possession arrests. In 2011, there were 196 murders, 2,178 gun seizures, and 1,224 weapons possessions arrests. And this is from the Baltimore City Police Department. Third, part of the challenge has been that while there's been more willingness to criticize police publicly, they are still primarily been able to operate how they historically have been and continue to be shielded from accountability for the misconduct that they commit, which has a significant impact on the public's willingness to cooperate with police in apprehending those who actually perpetuate violence in our communities. For the foregoing reasons, the ACLU of Maryland urges an unfavorable report on HB 135. Thank you, and happy to answer any questions you might have.
Good afternoon. My name is Heather Warnken, and I am the Executive Director of the Center for Criminal Justice Reform. The evidence is simply not there to support the new firearm penalty provisions in this bill as an effective deterrent to gun violence. And in fact, there's a large body of evidence demonstrating the ways they will undermine public safety. I want to be very clear. Addressing the immeasurable pain of gun violence and the growing number of illegal firearms in our communities must be of utmost priority. It is because we care so deeply about this crisis and the victims that it impacts, not in spite of it, that our center opposes this approach. Here are a few of the reasons why. Number one, the premise that these penalties will produce safety is based on a faulty set of assumptions about deterrence, which conflate certainty of consequences with severity of consequences, two very different things. Studies demonstrate that longer sentences do not deter crime. There is no reason to make consequences for these gun offenses more severe than the ones we already have. Number two, this bill will undermine public safety. Incarceration takes a staggering toll on a person's life, weakens communities, and has criminogenic effects. This bill will saddle individuals with unnecessary felony convictions, notwithstanding extensive data demonstrating the economic and other impacts of collateral consequences of a felony record. And number three, this bill is not an effective use of our resources. We welcome the opportunity to engage with members of this committee on alternate public safety solutions capable of producing a far greater return on investment, discussed at length in our written testimony. If we want to be serious about reducing gun violence, we need to address the reasons people are picking up the guns in the first place. We need to invest in, not destabilize, the hardest hit communities. We have to have the courage to give these evidence-based solutions a chance to work rather than to regressing to politically expedient yet utterly failed strategies of the past. Thank you.
All right, again, Davon Love, Leaders of a Beautiful Struggle. There's certainly things in this bill that we like. But one of the central pieces of the gun penalties, legislators have attempted to find new ways to enhance sentences as central to the crime fighting strategy. And actually gets quite frustrating in having some of these, not being able to have the conversation in full length as it needs. Turning a stolen gun into a felony that triggers additional penalties essentially allows an assistant state's attorney to have more leverage in a plea deal. A lot of people don't have the resources to pay for a private attorney. So much of this happens through a plea deal where a prosecutor has more leverage. This doesn't change your ability to actually get the folks who are the drivers of violence in our community. This just simply creates more leverage for the existing structure of law enforcement that has been determined based on actual evidence that, again, I continue to cite, has been incompetent and corrupt. And the evidence of that is tremendous. And so we can't expect to have a different outcome in terms of public safety if law enforcement largely remains in the condition that it's in. Even with many of the reforms, we still see law enforcement being charged with, a variety of different crimes and investigations that are happening, even under the consent decree, even under all these various different policies that this body has moved. So the problem really is not just the incompetence, the fractured relationship with the community, and also, again, as was mentioned in on one of the previous bills, the over-reliance on drugs and cannabis prohibition policy as a crime-fighting strategy. And I challenge anybody, Mr. Schellenberger, Senator Wallstreicher, the evidence on this question is overwhelmingly on my side. And I would want to be challenged on this claim, because if we're talking about how to address public safety, all we're doing is sucking more people into the criminal justice system by pursuing these policies. And these kinds of crime fighting strategies have not been effective. Someone point to where they have been effective, where these approaches to sentence enhancements have actually delivered on public safety. It has not.
Excellent. Thank you very much. Questions from the committee, Senator Carter.
Much, Mr. Chair. So Delegate Moon is still here, and even though this panel is here, I'd like you, if you can, to possibly respond to the question since it was your bill. But one of the things that I've been struck by over the last series of bills that we have about guns and other crimes is the fact that we already have a multitude of statutes that I've seen repeatedly that individuals with one gun are charged like 5 or 6 or 7 times with, different statutes that we already have in place. Mere possession, wear, carry, transport, prohibited person, and down the line. But what I find shocking is that our trafficking statute, which is a misdemeanor, I've never seen it charged. And I keep asking people, when is it charged? And I don't think it is being charged. And so I wonder, maybe you, Mr. Sponsor, or anybody on the panel could explain to me the efficacy of turning a first-time mere possession into a felony when there's a multitude of other statutes already dealt with, but not dealing with trafficking at all. That's a misdemeanor.
Sure, I don't know if I'm supposed to come back to the podium,
Yes, sir.
but I will. Excellent. Yeah, I mean, it's we got all the same folks here. So look, I actually was thinking about one of your bills in the past, believe it or not, as we were toying through how to construct the firearms section of this bill. And I think you had in the past an effort to trace the origin of crime guns. And, the hair of the idea there that I guess we seized upon was that there's something very different about the commerce of these illegal guns. And granted, you're talking about possession, but most of the offenses that we put in here are related to the commerce of firearms that are either anonymized or sold illegally without background check. So that's the unifying feature. I will grant you that if you look at the fiscal note, you will see that it's a little bit alarming that the number of charges that are currently lodged in Maryland for these types of offenses, it's very much on the ordinary offense and not on these specific commercial offenses. But again, that's part of the hope, I guess, of what this bill is trying to do, is to point the eyes of law enforcement to the commercial offenses. It's also part of the reason why I understand this is all open debate, but these firearm offenses were very much being discussed in the context of the larger basket of firearm bills that we have before us this session. As I noted, one of them was seeking to add years on ordinary wear carry violations, all of them, whether you were sort of in the stream of a crime or not. And so again, this was an attempt to take a smaller slice of that basket of firearm offenses and bills that you guys were looking at and just limit this to ones that were involving guns that were somehow procured in an untoward manner. Additionally, we didn't add to the penalties. Unlike the other bill, and I hate to keep using it as a reference point, but that other bill was trying to add randomly a couple years to a sentence. We didn't do that. 5 years was the penalty on ghost guns. We left it 5 years. 5 years was the penalty on stolen firearms. We left it 5 years. The only change that was a penalty enhancement is if you're selling a gun where you've deleted the serial number. And I think this body already made the policy call that if you're selling these anonymized and sketchy guns on the ghost gun debate, that's a 5-year penalty. So yes, I suppose on the anonymized guns, we went from a fine only offense to felony 5. But I would argue we already did that with the anonymous ghost guns, and this was really just an omission in the code. Now, again, from where some of the advocates sit, they might have wanted to leave that omission lie. But I'm just telling you, this was the bigger picture of the gun offenses that we were looking at. And again, trying to get at the concern that's raised about the proliferation of the illegal guns. I mean, that's sort of where all of these conversations on the gun bills have been pointing us. Everyone said the illegal guns, the crime guns. That's what I think we put in the bill. And we tried to do it without a straight penalty increase. But I guess we're drawing flack for that anyway, even though there are other bills you guys are looking at that actually do those things.
Well, I'll have more offline later, I'm pretty sure,
Yeah.
but I don't think that you did that because it includes the mere possession of a gun that was stolen.
That's
and makes
a
it
fair
felony.
question. I mean,
That's already really covered.
No,
in the law.
I'll grant you that. The intent, certainly when we were circling these laws, was to get a basket of bills about illegal guns in the stream of commerce. But these sections are all constructed differently. Some of them say manufacture, possess, some of them say receive, sell, transfer. The language is not consistent. You certainly could make the language consistent between the sections if you wanted to, and you certainly could make an adjustment as to the word possession. We talked about it, but it was more complicated to do than we had the time for flying through an omnibus. But you have a little bit more time to try and isolate possession out of the bill.
Thank you.
Thank you very much. For Mr. Schellenberger, I was reading your testimony. And I'm trying to think in my mind, how this works. So I think earlier on the last bill, you and Senator Carter, I think if we're talking about legalization. So legalization happens after July 1. Once that happens, does the whole concept of personal use, does that matter anymore?
Well, I think it still would matter. It's just the amount of personal use would be a larger amount. I mean, currently, it's going to be 1.5 ounces. That would be considered, that's what you all have decided is personal use.
Right. So, but once it's legalized, I mean, can somebody have 50 pounds of marijuana, or that will still be illegal?
That will still be illegal.
Even under the legalization scheme?
Yes.
Okay.
You can only have 50 pounds if you own one of the dispensaries.
Okay, so which is what I've been trying to work in my mind. So and so I'm just curious, we've been talking corollaries between alcohol and drugs. With alcohol, although I mean there's no necessarily large or volume amount that one would have government coming down and arresting someone who had a high volume of alcohol, right?
That's correct. We do not have enough jails for that.
So what we're doing is we're using government police to help with to stymie or to put down what is now illegal. But what some others are going to be making millions and millions of dollars on.
Well, but you all have decided that.
But this bill tries to get rid of that.
Right.
Okay, that's what I'm trying, all right,
Right.
thank you. That's what I was trying to.
And that's why it's hard because so below 1.5 is legal, between 1.5 and 2.5 is civil, and then above 2.5 is potentially criminal. And obviously 50 pounds is a whole different
Not personal.
conversation,
Right,
different
it's-
conversation.
Right, selling, right, got you, thank you.
Yeah.
Mr. Love, in listening to your testimony, it seems, and this goes back, I think, to one of the other bills we were talking about before, you seem to be suggesting that you've alluded to the whole idea of violence or marijuana not being a driver of violence. Would you mind elaborating on that?
So when we look at the data that is available, like even in the testimony on 1071, the conversation about gun seizures that resulted from odor searches, you would have a point if one could trace those seizures to a person who's considered a violent repeat offender. That would provide evidence that there is a connection. Such evidence does not exist. When we look at, now the evidence isn't comprehensive, right? There's still studies being done that are looking at what's the connection between drug trafficking and violence in communities, right? And the information about that is mixed. But what we see, and I've named a few examples of studies that have been done that demonstrate that if we're actually trying to address violence and we're trying to address homicide, the scientifically intelligent thing to do is to look at what are the larger universe of things that contribute to violence in the community. And what I'm suggesting is that the over-reliance on cannabis as an approach to dealing with public safety does not square with what the evidence that we have available says. And I have not heard from prosecutors or from folks that are on the other side of the argument, I've not heard very much scientific evidence that has been provided that makes that connection. It's an assumption that I think people make that comes as a result of pop culture, that comes as a result of certain inferences that are highly racialized, right? When we look at the caricature, and not that drug dealers don't exist, not that drug trafficking doesn't, cause problems. Drug trafficking is a problem, whether it's, Black folks in Baltimore or Prince George's County, or whether it's, pharmaceutical companies that overprescribe medicine to get profit that gets people addicted to drugs. So regardless of where drug trafficking happened, it is a problem. But I'm saying if we're talking about addressing the issue of violence, I've not been exposed to evidence that is scientific that makes the claim that the focus on cannabis has done that. And the past 50 years of policy on this question is really plenty of evidence to this extent.
Thank you very much. Thank you.
All right, seeing no further questions, thank you all very much. All right, we did, Harold, Mr. Morris, you're here. I'm gonna make sure I'm gonna have you as the last, because you're there are a couple of folks that may be still here that want to testify, and then I want to make sure that because you're a proponent of the bill. So is Rusty Carr, we have Elizabeth Hilliard. Jason Billingsby has already testified, is that right? Have I missed anyone else? All right, and then we'll end up with Mr. Morris.
Good afternoon, nearly evening, members of the committee. I am batting cleanup today. I'm Elizabeth Hilliard with the Office of the Public Defender, and I'm just going to speak briefly to two of the laws that are proposed to be changed by this bill and why it is premature to change them. The first are the changes to 5703. Just last year, the legislature passed the bill that created the crimes articulated in 5703. We have no data or understanding of how that law is being charged, of how people are, whether they are being deterred or receiving felony convictions under it, or any statistics on the periods of incarcerations that have been, the amount of fines that have been leveraged. Without that information, it is premature to change the scope of the potential impact that could be caused by that law. We know, and it's extensively discussed in our written testimony, but felony convictions have a sincere and severe impact on people. They can prevent people from accessing housing, student loan grants, even volunteer opportunities with the federal government are restricted if you have a felony conviction. So we are asking this committee to consider allowing the law that already exists, a few years at least, to demonstrate whether it is effective or sufficient as a misdemeanor. Similarly, the 5408 law, our office has no records of that being charged in the last 2 years and only one record of it being charged in 2020. If it's not being used or very, very irregularly used, we argue that it should not be increased to a felony conviction. Thank you.
Thank you, Chair Smith and members of the committee. My name is Rusty Carr. I'm a resident of Mount Airy. I am here today to object to this bill. The war on drugs has been corrupt from day one. We have a quote from John Ehrlichman when cannabis was put on Schedule 1 that says, "Did we know we were lying about the drugs? Of course we did." The penalties for cannabis distribution should be on par with the penalties for alcohol and tobacco distribution, not equivalent to the war on drugs. The people have spoken. We asked this body to end the war on drugs, at least with respect to cannabis. We did that because prohibition doesn't work as a matter of public policy. I ask you, if you're going to reenact this kingpin law, what do you expect is going to happen for fentanyl? Does this prosecution of kingpins actually work? If it doesn't work, why are we continuing it? Why are we trying to patch something that doesn't work with an exception for cannabis when we should be dropping cannabis from the list altogether? And in fact, we shouldn't be prosecuting the war on drugs either. It doesn't work. The people have spoken. We're going to fix it for cannabis. Take cannabis out of this bill. End the war on drugs, please. Thank you very much.
Excellent. Thank you both very much. Seeing no questions from the committee, that'll end the testimony for this panel. We'll now move on to our virtual participants, and then we have Mr. Morris. So we'll start off with Mr. Kerr, and then Mr. Steiner, you're up. So Mr. Kerr, go ahead.
Thank you. Good afternoon, everybody. My name is Jonathan Kerr. I currently teach at the Criminal Defense and Advocacy Clinic at the University of Baltimore School of Law. Until very recently, I was a public defender in Baltimore City for about 10 years. And I'm testifying in opposition to the parts of Delegate Moon's bill which changed the punishment for various firearms offenses, reclassifying them from misdemeanors to felonies. As has already been spoken about, and as you're no doubt familiar, felony convictions have wide-ranging and long-lasting repercussions, and I've personally seen this with many of my clients. And the issue with this bill is it results in yet more offenses which carry a felony conviction, including for first-time offenders. And Senator Carter, I think, was alluding to this earlier, but in the case of an individual who has no criminal record, who's found to be in possession of a gun, it serves no useful purpose to saddle them with a felony conviction, especially when they can already be charged under existing law with a variety of misdemeanor offenses. For example, a young man with no criminal record who briefly holds a stolen firearm or a firearm without a serial number could, under this proposed law, face a felony charge under Public Safety 5138 or Public Safety 5703, arising from the same conduct that would currently only subject him to a misdemeanor possession of a handgun charge. There's already plenty of tools available to charge and prosecute those possessing guns illegally, and there's no reason to burden them with a felony conviction for the same conduct. If the goal is consistency, then these should all be misdemeanor convictions, and that would be consistent.
Excellent. Thank you very much. All right, Braden, you're up.
Thank you, Mr. Chairman and members of the committee for the privilege to speak before you today. My name is Braden Steiner, and I'm a third-year law student and research fellow with the University of Baltimore Center for Criminal Justice Reform. I'm here today to stand in opposition to any and all attempts to further the use of unnecessary incarceration and felony charges as a tool to end the urgent crisis of gun violence. This strategy has been employed and over-relied on since the inception of our criminal legal system and has proven at every turn by numerous measurable statistics and bodies of evidence to be ineffective. Further, this failure of continued over-reliance on harsh criminal penalties has destroyed and deepened the challenges of impoverished communities, and in particular, communities of color throughout the United States. Maryland is no exception, and it's unique in its employment of these racist practices, leading the nation in racial disparities through its over-incarceration of Black men and youth. As horrific and harmful this reality is, Maryland also has the opportunity to lead the fight in correcting this malpractice by investing in far more effective public safety strategies. The data, as well as the voices of community members, tell us the solutions are out there. More in-depth analysis can be found in our center's joint written testimony, but briefly, correcting the generational harm of our current practices begins with addressing unmet needs at re-entry, developing further support through government funding for community-based organizations and academic institutions, as well as growing the capacity of anti-violence programs like ROCA's evidence-based cognitive behavioral therapy model to reach more impacted individuals at the highest risk of gun violence to effectively, sustainably interrupt cycles of harm. The hole that is left in communities targeted by policies like the heightened penalties proposed in this bill will deepen our challenges of generations of children lacking a sense of safety, community, and parental support. We must address the root causes of gun violence and heal the trauma left in its wake in order to prevent it. I'm the next generation of the legal profession working to solve societal problems, and I know there's a better way. Thank you.
Excellent. Thank you very much. All right. Seeing no questions from the committee, that will conclude the testimony for our virtual participants. And now we'll have up Mr. Morris, who signed up in support of the bill.
Thank you, Chairman and committee. My name is Harold J. Morris, Jr., and my family has been affected by the marijuana kingpin statute. My son is 34 years old with 4 children, has been sentenced to 20 years without parole for marijuana only. There was no guns involved. Just to be clear, we take responsibility for his actions, but we cannot accept that he will be in prison until he's 50 years old with no direction and not being able to resume his family life when released. As it stands, marijuana kingpin has a 20 years mandatory minimum sentence without parole and can cap out at 40 years without parole. Pretty much a life sentence for a non-violent crime. I keep hearing people who oppose House Bill 135 that they don't want to create a black market, and we want to send a message to people trying to do so. But isn't 20 years enough? This bill still carries 20 years for these offenses, but just removes the mandatory minimum. So it's parolable. Just want to say not everyone involved in large amounts carry guns, as my son did not. This bill takes out the mandatory minimum for kingpin marijuana, which still is a 20-year sentence. If the judge feels necessary, they can go even further than 20 years, depending on the situation. We also need to view this in a public safety matter. Being prisoners are classified for their time, not their charge, is putting away non-violent criminals for life. Public safety is putting a non-violent marijuana offender in prison with violent criminals. Public safety? I don't think so. Is 20 years with parole for an individual? Does that reform an individual? I don't think so. It's only cruel and unusual punishment. Bottom line, drug kingpin has no place for marijuana. I'm asking the committee to vote in favor of this bill in order to give judges the option to give proper sentencing to certain individuals to keep a better public safety policy and to reunite separated families. As far as reconsideration goes, I don't think people who were violent will get the relief.
Excellent. Well, thank you, Mr. Morris. I know it's been a long day. Thank you for hanging in there, and I enjoyed meeting you a couple days ago and hearing your story. So just thank you for your advocacy and thank you for hanging in there with us.
Thank you for having me. That's all.
Appreciate it. All right, always a pleasure. All right, with that, that'll conclude the hearing for House Bill 134 and our hearings for today. Tomorrow we have floor at 11. So we're gonna go ahead and vote after floor tomorrow. Okay, so that'll end our hearing and our work today.